Hi, everybody. Thanks for joining us today. We're going to talk a little bit about the challenge with workers' comp and ADA when things don't actually go as smoothly as you would want them to, and maybe you can't accommodate their usual and customary job, and there's a differential in play of some sort. So if you're in a state that has workers' comp, this is an interesting scenario for you. The employee's been on workers' comp for more than 3 months with restrictions, but they haven't been off work. They just have restrictions at work. They've been reasonably accommodated that whole time with a different department. And of course, their job was left open for them because you can't post a job when you put a workers' comp employee on light duty until you have determined you cannot accommodate them in their usual and customary job. And you'll be looking at a permanent alternative job, or you would be fighting leave. Leave would not be would not be under ADA at that point because it was an undue hardship to leave the job open. So that's why they went on leave, maybe on FMLA or just work comp inactive status. And then at that point, you would post the job because it was an undue hardship to leave the job open. That's a different conversation, but we want to go through this scenario, and I wanted to point that out so you're aware of that nuance. Workers' comp is treated a little bit differently when you got ADA because you always have to deal with the American with Disabilities Act, whether it's workers' comp or not, until you've determined it's an undue hardship to accommodate or provide leave, and you looked at all the other jobs you could put them in or accommodate with leave or accommodate with the restrictions. That's the ADA piece. So until you've done that, don't post a job because somebody's been put on light duty or inactive status, unless you've already determined that it's the ADA has been denied for that job. Side note. So the employee's been reasonably accommodated in an alternative department. So that means they left their job open and now that opportunity is ending. The employee now has requested to be transferred to a department from a full-time position to a part-time position because the part-time position will allow their restrictions to be modified, and they can go to work, and they want to work. They need to work. The employee was transferred to the new department, and now their job was posted because they have permanently requested a transfer from a full-time to a part-time position because it would accommodate them, and that's what they were looking for. Now, it took some time to get them crossed over to that new job. And now they're having challenges with financial issues. And they've been referred to employee health. They've been referred to HR. And they're indicating that the cause of their financial hardship is the time it took to manage the leave while they were trying to get them identified and placed in the alternative new job. The time it took to manage placing him in that alternative job while he was on leave, he wasn't getting compensated. He was only getting the workers' comp. There was a delay in getting the workers' comp money because it starts and ends, and there's always a delay before it starts. And so this man was impacted. And they're saying that the cause of their impact, their financial impact, was the temporary leave of absence accommodation that they received and the delay in the workers' comp compensation. And they wanted me to give them some feedback on how you would manage a case like this moving forward in the event the employee claims an exasperation of the existing injury, especially if they start having to work mandatory overtime hours. Okay, so we've got an issue of money, and the issue of money would be how quickly did you engage in the good faith interactive meeting, identify the part-time accommodation that the employee informed you they wanted them to move? How long did that take from the time they informed you and you responded? Now, if we're talking about a couple of days, we're not talking about a big deal, but if we're talking about a couple of weeks just to get something processed, you might want to be looking at who was responsible for the delay. And if you feel that there was a level of competency that maybe could have been improved, that this person did get harmed in some way, and you are going to increase their PTO or in some other way provide them a loan potentially where they could be paying it back with a little bit out of their paycheck. There's a lot of organizations now that are starting to create emergency funds for their employees, especially the lower paid employees that are so impacted when some of these things happen and the check doesn't come and they're living paycheck to paycheck. And they're valuable employees, so we want to help them without it being a major problem or access. So there's different ways to provide funding for employees in these issues. And I would just say that if you're talking about a couple $1,000 issue here, if you look at the numbers, that's very different than taking 3 months to resolve this. If it took that long, there's really a concern about the efficacy of your ability to engage in the interactive process and move forward with a request, because it should not take that long. So now the second part of this is they're saying because of that, they now have a medical condition that is being exasperated. Okay, well, I'm not sure when any of that would ever come up unless there was a termination or a suspension of some sort, and they felt that there was a personnel action that occurred and that you impacted them inappropriately, and somehow they started something like that. But other than that, this is really an employee reaching out and asking for help. Well, they are trying to get benefits under workers' comp with ADA. There's one other caveat with ADA that's very important with workers' comp. When an employee is on a workers' comp leave and they are protected under FMLA, everything's protected, including their job. As soon as FMLA ends and they're in an ADA protected environment, then at that point, the question is, will they be able to do their job when they return from the leave? And if it's determined after a couple of extensions that no, they can't, and now it's an undue hardship that you're putting them on leave and you can't continue to keep their job open, you would then post their job at that time. But, and this is an important but, everybody, if and when the medical certificate becomes less restrictive, every time they give you a new medical certificate extending their treatment for their workers' comp injury, and it gets less restrictive, you are re-engaging in the interactive every time you get that new medical certificate under workers' comp, because you're determining, well, maybe their job hasn't been filled yet, and they could do it now with their current level of restrictions because they're a little less, or there's some other job in the company that they can do with those current restrictions that is a little bit less, or there's another job in the company that you could leave open that they could do with those current restrictions that would not be an undue hardship, or that you could leave open till the end of the current restriction time frame to determine they could then come in and do it at that time. And the expectation is they could. That's why they'd be available for that job if you could leave it open. And I know when I hear myself, it sounds a little confusing. So I hope that didn't occur. But please, if you've got comments or questions about any of these blogs or posts that we're putting up, put them into the site, and we will respond with to your question with some feedback, maybe another short video. So let me get to the rest of it to see what else they actually asked. They said that was going on. So they said, regardless of the effort to reasonably accommodate them in the past few months, they're still thinking that they might have their injury exasperated. Well, if at any time an HR person who's responsible for accommodations under the ADA with workers' comp is being informed that they feel a request for an employee to perform their job with exacerbated injury, that could be considered imminent harm. Now, imminent harm under the ADA could be a undue hardship or a reason why it's not reasonable to accommodate the employee. But we're already accommodating them, and they're just saying that they are getting stressed because of the potential mandatory overtime. Now, the accommodation of mandatory overtime would flip back to FMLA first, everybody. Take a breath. If they're eligible for FMLA and there's mandatory overtime that is going to impact a serious medical condition or a disability, you would simply apply FMLA during a mandatory overtime till the FMLA was exhausted. Then once the FMLA is exhausted, if they still can't do the mandatory overtime because they're concerned about an exasperation, and it's been documented by their doctor that they are also, then at that point, you are actually looking at an accommodation for the mandatory overtime. And that might work for a couple of employees in the department. But if you've got a department of 5 and 3 of them have an accommodation for no mandatory overtime, it's going to be a problem. Who's going to do the overtime? And then it becomes an undue hardship to provide anybody else an accommodation for release of mandatory overtime, because we have to have everybody else in the department perform that function. So these are a bunch of little nuances and strategies that are not specific to the regulation itself, but it's specific to the methodology you use to implement that procedure and that compliance and that policy. And it's a consistency with which you implement your standard operating procedures of your policies with your compliance regulations that really, really make sure you lock down protection for your company. And there's a lot of little strategies that we're going to share with you on the blog. So let me just check one more time to see if there's anything else that I haven't answered. So the last statement is, there's a concern that this employee may use the work comp issue as a reason to why they experience financial and emotional hardship. Well, it could be true. If the work comp medical issue is impacted by the mandatory overtime, that's a real issue under ADA, FMLA first, irregardless of workers' comp. And remember, with workers' comp is always FMLA or ADA at all times until they've exhausted FMLA or they're not eligible, or you've determined it's an undue hardship to accommodate under the ADA and they are no longer being covered. Now it's just workers' comp, but you have to have gone through those steps. So right now they're saying, wait, we got to do a good faith interactive meeting. We've got a reason to believe the employee feels they will be medically impacted if they work mandatory overtime. Now, this said it was a part-time job, so my guess is sometimes you have to work over 8 hours a day overtime, and that could be the challenge as opposed to over 40 a week. But anyway, if it was 40 hours a week and there was mandatory overtime above a normal work schedule is still a requirement of the job and an essential function. And you either can accommodate it or not. And how many people can you accommodate with mandatory overtime releasing before you have the organization impacted? That would be the undue hardship discussion. So they need to confirm whether they can or cannot accommodate them. And if they can't accommodate them, would you be keeping an employee on the job that has already informed you the use of mandatory overtime could potentially impact their medical condition? I would never be doing that unless a doctor has fully released them to work that mandatory overtime. And if they aren't and they don't, then you really are looking at the ADA. Okay, so let's say we determined it's an undue hardship to provide the mandatory overtime. She's not going to be able, or he's not going to be able to do this job either. And now we're looking at any other job in the company. And I think what they're leading towards, what if we end up with a wrongful termination claim and they bring up the workers' comp issue and the failure to accommodate in a timely manner as impacting their ability to work, impacting their conditions so they could not work the average mandatory overtime and impacted their wages and hours. Those are real lawsuits, everybody. These are the kinds of things that come up. And so what we want to do is make sure you've thought about how to manage the process for your employee so they aren't impacted. And in this case, time was a factor. We don't know how much, and they'll have to take a look at whether the mandatory overtime really can or cannot be accommodated and what responsibility they may need to take for some of this because they took too much time accommodating in the first place. So I hope that helps everybody understand some of the confusion that occurs when you start layering these regulations on top of each other. And that's just a short overview. I just want to say thank you very much, everybody, for joining us today. If you've got nuances like this that are happening in your organization, That's what we're here for. Submit your questions either through the chat or on our Facebook page or the LinkedIn page, and we'll be happy to see if we can help you out. Take care, everyone.